welcome to this week's edition of CGConnect, brought to you by Clifford, Gouldson lawyers. As you can see this week, I'm at the Japanese Gardens at the University of Southern Queensland, and what a great setting for this week's vlog. CGConnect is our weekly video blog where we share with you the experiences we, our clients and our referrers are having in business across the region. This week I thought I'd speak with you in relation to workplace law. Over the recent years, since 2009, there have been new rights for workers under the Fair Work Act. People would generally be familiar with rights for workers to bring unfair dismissal claims if they're terminated from their employment and feel that that was harsh, unjust or unreasonable. What a lot of businesses are experiencing in the recent period are what are called adverse action claims. Now these are claims where workers can bring an application in the Fair Work Commission and argue that they are being treated adversely by their employer. Danny Clifford and our workplace team at Clifford, Gouldson lawyers has certainly seen a spike in these claims over recent times. Statistics released from the Fair Work Commission suggest that in the last quarter to 31 December 2016, there was a spike and nearly 1,000 of these claims were lodged. The trend that we see is that as workers become increasingly aware of their rights, the likelihood is that these claims will continue. The law in Australia on what constitutes an adverse action isn't yet settled. A number of commissioners from the Fair Work Commission are taking differing interpretations of just what amounts to adverse action in the workplace. And certainly some of the early decisions seem to indicate that what constitutes adverse action in the workplace will be far wider reaching than you might have first thought. What this means for employers, in our experience, is that employers need to be ever more vigilant and be cautious around the steps that they are taking with their employees, whether it be performance counselling, disciplinary action, or responding to requests the employees may make in the workplace day by day. One critical thing is to have your policies and procedures in place and clear, and another issue is to make sure that when you're taking any of those steps against workers, you are very careful in the way you go about that. If you'd like to reach out to Danny and the team at Clifford Gouldson lawyers, please feel free to do so. It is a tricky area, and some of the caps on compensation or damages that apply in the unfair dismissal regime don't exist in the adverse action regime. Until we speak again, all the best to you, your family, and your business. Bye-bye.